Hey, good morning, Todisi.
Morning, Chairperson. How are you?
I'm in a cell.
We are
I
very well,
believe
Chair.
today the system won't disappoint us.
Yes, no, we did the testing earlier, Chair. We don't foresee any technical glitches for today.
Okay. I appreciate that. Thank you. You will inform me when is the right time to start.
We'll message you, Chair. Thank you.
Thank you.
Recording in progress.
Good morning, honorable members, our officials, the legal team from the affected members and our initiate advocates. I welcome you all, members.
Good morning, Chair. This is the initiator. My learned colleague, advocate, the advocate for the EFF. We are just waiting on him.
Okay, thank you. You will indicate to me when he has arrived. Thank you.
Chair, here he is. He's just going to take his seat. Thank you.
Thank you, initiator. Good morning, honorable members, our legal team, and our officials, our legal teams, both from the affected members and our initiator. I welcome you all members to the resumption of the hearing, which started on Monday, the 11th of December, 2023. I just want to check whether there are any apologies from our staff. Do we have any apologies?
We don't have any apologies, Chair.
Thank you. In the absence of apologies, I now request the initiator to make a closing argument. Chair has 30 minutes to do so. Over to you, initiator.
Thank you,
Advocate
Chair.
Gordon.
Thank you, Chair. Chair, I will start off by just referring to section 13 of the Act. This is section 13 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, number 4 of 2004. I will read out section 13, Conduct Constituting Contempt. A member is guilty of contempt of Parliament if the member A contravenes section 7, 8, 10, 19, 21(1) or 26. B commits an act mentioned in section 17(1)(a), b, c or 2(a), b, c, d, e. C willfully fails or refuses to obey any rule, order or resolution of a house or the house. Or D, commits an act which in terms of the standing rules constitutes Roman numeral 1, contempt of Parliament, or Roman numeral 2, a breach or abuse of parliamentary privilege. Chair, in terms of section 13A, sections 19, 21 and 26, well, more 19 and 21, does not concern this hearing. They deal with unauthorized publications and broadcasting. So that is not relevant here. I ask that the committee and you, Chair, read section 13 together with section 7 of the Act and sections 12 of the Act. Section 12 deals with the disciplinary action against members for contempt. But insofar as the charges are concerned, and the discharge of the onus upon me as the initiator, section 13 is then the relevant section. I will then just proceed to my further oral submissions. Chair, the charges against the members are the following. Charge 1 is common to all 3 members, save that the contravention of Rule 69B and Rule 69E of the National Assembly rules have been included in the charge sheet of Mr. Paulson. Rule 69B, as you know all too well, deals with the physical intervention or obstruction of any member or staff member. 69E is the reference to using or threatening violence against a member or other person. So these have been added to charge number 1 for Mr. Paulson, but all the other contraventions are common in all 3 members for charge 1. And before I go any further, I wish to make it clear that I do not pursue a charge that Mr. Paulson threatened violence against the PPS officials. Chair and committee, you will recall that on Tuesday, during cross-examination of Mr. Paulson, I pertinently put it to him that I will not rely on that part of section 69E which deals with a threat. Then the members have also, they also have additional charges specific only to their conduct. In relation to Mr. Teza, charge 2 is that he disregarded the authority of the chair and was asked to leave the chamber. We all know from the video footage that he refused, and then the sergeant-at-arms was instructed to remove him. He refused, which then compelled the speaker to call in and instruct members of the Parliamentary Protection Services to physically then remove Mr. Teza. He also failed to act in that he acted in breach of sections 13C and 13D of the Act when he refused to leave the chamber. You will recall that I put it to him that those were further contraventions of the National Assembly rule. In relation to Ms. Menti, and specifically in relation to charge 2, Ms. Menti persisted to speak while the speaker addressed the House and refused to leave when ordered to do so by the speaker. She was compelled to call, this is the speaker now, the sergeant
They're
at
withdrawing the
arms.
charge. They say I threatened. They are now just you.
Sorry, Madam Chair. It
Who's-
seems that Mr.
who's
Paulson
speaking?
interrupted.
Honorable Paulson, can you be orderly, please? Please. I'm requesting you to do that. Initiator, please proceed.
Thank
Chairperson,
you,
my
Madam Chair.
apologies.
In relation
not-
to
it
charge
was-
2, Ms. Menti persisted to speak while the speaker addressed the House and refused to leave when ordered to do so. She was then, that's the speaker, compelled to then call the sergeant at arms to remove Ms. Menti or to ask her to leave. We know that she refused and that the speaker was also compelled to call in the Parliamentary Protection Services to physically remove her from the chamber. Charge 2 also alleges that Ms. Menti acted in breach of section 13C and 13D of the Act when she refused to comply with the speaker's orders to leave. There is a further charge, and that relates to charge 3, where she refused to withdraw disturbing and or threatening and or unparliamentary remarks that she made to Ms. Mgweba when ordered to do so by the speaker. She was ordered to leave the chamber for disregarding the authority of the chair, and we know that she refused to do so. That is not in dispute. The sergeant at arms was called or instructed to ask her to leave. She refused, and the speaker was compelled to invoke Rule 73(2) to call in the PPS to physically remove Ms. Menti. And then in relation to Mr. Paulson, in relation to charge 2, was that he hindered or obstructed the PPS officials from executing the physical removal of Mr. Teza. This was, I submit, a flagrant breach of Rule 69B and or Rule 69E, and then also Rule 73(5) of the Rules of the National Assembly. And then I now briefly turn just to summarize just the most relevant parts of the evidence. Chair and committee, we rely on the video footage of the proceedings in the National Assembly on 30 August 2022. We rely also on the Hansard unrevised transcription, which is the verbatim transcription of what was said in the House on the day. We also rely on Mr. Kaso's evidence. You will recall that Mr. Kaso was present, personally present, in the House on the 30th and personally observed the conduct of the affected members. And then we also rely on the affidavits which we have submitted into evidence. Now, just to confirm that my learned friend did say up front, I think before the commencement of the hearing, that they do not object to the admission of the affidavits for the technical, where the technical evidence is concerned. However, they do not accept the affidavit evidence of the Parliamentary Protection Services as they wish to test their evidence. My learned, I hope that I have accurately captured the position of my learned friend, but I'm sure that if I am wrong, I apologize, but if I am wrong, then I'm sure he will rectify me during his address to you. With the result, committee, that all the other evidence on affidavit is then submitted with no objection. And I respectfully submit that the committee is then, or can then, rightfully rely on that affidavit evidence to the extent necessary. Now, although the members gave evidence in their own defense, their evidence committee and chairperson does not at all disturb the evidence led by myself as the initiator, as assisted by Advocate Magona, namely that Mr. Kaso, the Hansard description, and very importantly, the video footage, which really speaks for itself, what all of those evidence confirms. The committee is obviously able to very easily arrive at its own conclusions from the video footage alone. It was abundantly clear that members, the affected members, Mr. Treza, Mr. Paulson and Ms. Menti, caused and contributed to a huge disruption and disturbance in the National Assembly on the 30th of August. Their behavior was sufficiently bad for the Speaker to instruct them to leave, which in actual fact they refused to do. It is also clear, Madam Chair and Committee, that they blatantly disregarded and disrespected the authority of the Speaker when she made certain rulings and when she ordered that they leave the House. Now, I just want to pause in summary, or to summarize the evidence really of the individual members. I will not be long, Committee. In relation to Mr. Treza spoke without even being recognized, and he raised the issue of Pala Pala. He insisted that the issue of Pala Pala is dealt with immediately. And Chair, during the course of cross-examination, I made reference, extensive reference to the Hansard description, to which I refer you to again. And he raised, Mr. Treza, the issue of Pala Pala in circumstances when the Speaker made it very clear on more than one occasion, as can be seen again from Hansard and the video footage, that it was not the question that the House was dealing with at the time. They were still dealing with the first, or maybe they touched on the second question. But she made it clear that there was an order paper and that the questions were arranged in order on the question paper, and that the members who raised the Pala Pala question would have an opportunity later on in the proceedings to raise that question. However, certain members of the EFF, including Mr. Treza, did not respect the Speaker's ruling and her direction, and repeatedly raised the issue of Pala Pala. and so did Mr. Treza, which then led to the Speaker making a ruling that he should leave the House. Rightfully so, I submit. So my respectful submission is that Honourable Treza clearly defied the Speaker and disrespected her authority. She correctly asked him to leave. He refused. It's not in dispute that he refused to leave. It is also not in dispute that he was defiant when the PPS came in to execute his physical removal. In relation to Ms. Menti, I refer to the video clip, and I also refer the committee again to pages 388 to 392 of the Hansard transcription, which clearly shows Ms. Menti's blatant defiance and disrespect for the Speaker. The record shows and the video footage shows that she blatantly refused to withdraw her remarks. Hansard clearly shows that she acted, in my respectful submission, willfully, as she repeatedly refused to obey the Speaker's instruction. On page 388 of Hansard, Ms. Menti says very defiantly, "I will not withdraw." Committee and Chair, I wish to remind the committee that Ms. Menti never once denied in the House on the 30th that she made the remarks that she was accused of making to Ms. Magweba. Not once. It was only later on in the proceedings and after the Speaker repeatedly asked her to withdraw that she opportunistically told the Speaker, "What must I withdraw?" Page 390 of Hansard shows, and this is what I quote in inverted commas, this is what she says to the Speaker. Secondly, she threatened my member. "I must sit here and be quiet while my member is threatened." That is what she said. Committee, this strongly suggests that she said something to Ms. Magweba. However, when the committee asked her, Ms. Menti, to take the committee into her confidence and to share with the committee what in fact she told Ms. Magweba or what the remarks were that she made in the House, she blatantly refused. So, in my respectful submission, Ms. Menti's defiance continued even in this hearing. She refused to take the committee in her confidence. On the contrary, what Ms. Menti sought to do was to deflect away from her conduct, and her approach was rather to say, "But there is nothing on the Hansard that reflects what I said." Page 391 again shows her willfulness and defiance when she refused to withdraw her remarks. In relation to Mr. Paulson's conduct, committee, the video footage again speaks for itself, and the committee can draw its own conclusions and inferences of what you are able to see on the video footage. The video footage shows that Mr. Paulson not only physically obstructed the PPS members from removing Mr. Treza, but that he also physically pushed the PPS officials back and tried to push them out of the way. Mr. Kaso was, in my view, still being kind to Mr. Paulson in his evidence when he testified that Mr. Paulson had tried to stop the PPS in an unfriendly manner. With respect, committee, it went far beyond just an unfriendly manner. We must, however, call Mr. Paulson's conduct for what it was. And committee, you will be reminded that when Mr. Paulson gave evidence, both in cross-examination and in re-examination, more in re-examination, Mr. Paulson was blatantly defiant even to these proceedings. In actual fact, his words were, and both my colleague and I tried to take it down word for word, but the essence of his evidence was, we had to defy. Defiance was the only way to go. It was the only answer. So Mr. Paulson clearly admitted very freely and with no restraint whatsoever that he openly defied the speaker. The excuse or explanation that was given by both Mr. Keza and Mr. Paulson as to why they refused to leave the chamber or the house and why Mr. Paulson stopped the PPS is, with respect to both of them, contrived. They both testified that they were waiting for Mr. Malema's engagement with the speaker to finish on the issue of a warning. Mr. Paulson testified that he first wanted confirmation that of Mr. Malema's engagement with the speaker, where Mr. Malema called for a warning first. He wanted that engagement to be finished, and in the words of Mr. Paulson, he wanted confirmation that Mr. Keza should have been warned. However, committee, the chair shows that there was no such engagement whatsoever. The record does show that there was a continued and persistent defiance of the speaker, which only created a further disruption and disorder in the House. Chair, you will also recall the evidence of Mr. Kaso that the speaker is not at all obliged to first warn a member that they are going to be removed. There is no such rule that exists in the National Assembly rules. I wish to point out that Mr. Tabelo Malimi, who is the acting Sergeant at Arms, has confirmed in his affidavit that the speaker instructed him to ask Mr. Paulson to leave, and when Mr. Paulson refused to leave, the speaker then called in the Parliamentary Protection Services to remove him. I also remind the committee that his affidavit is now on the record and has been accepted by the EFF's legal team. It is our respectful submission, committee and chair, that on the evidence of Mr. Kaso, the video footage, and the Hansard transcription and the affidavits which have been submitted, that the affected members impeded the function of the National Assembly on the day in question. They undoubtedly caused and or contributed to the disruption and very serious and grave disorder in the House. They certainly took part in the disturbance. The disturbance and the disorder, from what we heard in Mr. Kaso's evidence, it delayed the proceedings for almost an hour. On the facts, the members deliberately took part in the disorder and in fact aggravated the disorder, which was seriously detrimental to the decorum and dignity of the House. You will recall, as I have said previously, perhaps it's worth repeating, that the business of the House could only resume after almost an hour of the disruption. We accordingly ask committee that the members be found guilty of contempt of Parliament as contemplated in section 12, read together with section 13 of the Powers and Privileges Act. Those are my submissions, and I would like to reserve my right to reply to any submissions which my learned friend seeks to make and which I already have not dealt with in these oral submissions. Thank you, Chair.
Thank you. Initiator, let's proceed. I will now allow members of the committee 15 minutes to ask only clarity-seeking questions to the initiator. Let us show this by a raise of hands, honorable members. Honorable Mlenzana, you are the first. Over to you.
No, thanks. Thank you, Chairperson, and good morning to all, both at M46 and the platform. Chairperson, whilst appreciating the presentation, mine is just but one question. During the course of the proceedings, the initiator would recall that in the statements which were filed, there was also element of the regard, in fact, the high regard of the invitees, the guests who were part of the occasion that was actually jeopardized. Now, what does that say to the onlookers, those who were watching outside Parliament, going even abroad? And two, the initiator also mentions not but once the fact that the time which was scheduled for that session had to be delayed by almost close to an hour. Now, in rands and cents terms, in monetary terms, how can she perhaps relate to that delay in terms of the costs that were incurred by both Parliament and the guests and whoever was watching the jeopardized occasion? Thanks, Chairperson.
Thank you, Honorable Mlenzana. Honorable Deputy Chief Whip, number 2.
Honorable Chairperson, I'm sorry I don't have a clarity-seeking question. Thank you.
Thank you, Honorable Deputy Chief Whip. In the absence of other hands, I will now invite, I will now request the legal representative of the affected members to make his closing arguments. He has 30 minutes to do so. Over to you,
Sorry, Chair, am I am I not required to respond to the
Okay,
committee
sorry,
members' questions?
sorry, you are required to respond because they will ask clarity seeking question to advocate after his closing arguments. You may do so.
Thank you, Chair. In relation to the first question, the impression that the disorder and disruption created with the guests and outsiders, and also even it was obviously accessible and broadcasted on YouTube. It was live streamed on YouTube, so that means anyone could have watched it anywhere in the world, and I'm certain that did happen. Certainly, there were thousands or hundreds and thousands, if not millions, of people who watched the broadcast on that day on the television sets. So, committee, it obviously created a very, very bad impression of the South African Parliament in general, that it is beset by disrespect, disorder, and a disregard for the presiding officer who was the speaker. So it made a very, very bad impression all around. The fact that the proceedings were delayed, and that I will try to answer question number 2. The delay of the business of the House on that day obviously had some repercussions for the House itself, because it could not continue with the business of the House as it was scheduled to do. And the business of the House is obviously an obligation of Parliament in order to execute its function, its duty, and its role to the people of South Africa. So that, in my respectful submission, is quite a serious repercussion or consequence. The committee member also asked me to comment perhaps on what the costs would be, or repercussions relating to costs in rands and cents, which may have been incurred in relation to the delay, or which was caused by the delay. I am unfortunately not able to meaningfully comment on whether it had a monetary effect or whether there was wastage of costs, because I don't have that information. However, I would like to say that it was serious enough that the disturbance and the disorder in the House created a delay, which meant that the House could not perform its function as it was required and obligated to do in terms of the Act, and also for the people of South Africa. The disruption certainly also caused the delay certainly also impacted all the citizens of this country who had made time in their day to watch the proceedings as it was live streamed. Thank you, Chair.
Thank you, Initiator, for the response. I will now request a legal representative of the affected members to make his closing arguments. You have got 30 minutes to do so, Advocate Kasibote. You may start. Thank you.
Thank you, Chairperson. Can I please, just before my time starts running, address this issue, if you don't mind, Chair? It's an issue that has nothing to do with my submissions, just a question of procedure. So I ask that the time don't start until we resolve this aspect. The initiator has suggested that she is reserving her right, she calls it, to reply. This is no different from a trial I submit to you, Chairperson. I accept readily, and I did not contest it, that at the stage evidence is being led, of course, You lead your witness in chief, then there's cross-examination, and then there's re-examination. So I don't take qualms with that aspect. What I certainly take qualms with, certainly in terms of natural justice and how you typically run trials, which is in essence what we're doing here, you don't have a right to reply in submissions. And I'm suggesting to the chair that it would be grossly unfair to have the initiator address this committee, which she has for 30 minutes. She's got a second bite to address the committee as she has now. She then has a third bite in reply to address the committee again, when all I have are the 30 minutes that have been given now. I mean, there just can't be justice in that. I'm suggesting to the chair that you give us a ruling on this. My suggestion is, as you run trials in the ordinary course, there is no right to reply to submissions. What she has already is a second bite at the cherry, which goes beyond the 30 minutes she was allocated when responding to the committee members, and she'll have another one later on. And I'm asking, Chair, that no such right exists, and that you rule on that. Thank you, Chair.
Thank you, Advocate. Your concerns are noted. My understanding is that, Advocate, if you are given 30 minutes according to the schedule, if you still have got something to say beyond that, you have got those rights to request from the chairperson, and no one is going to deny you that, even more than that. And that's what I was always doing. On issues of time, to both of you, special to yourselves, I wanted to make sure that I don't deprive you because you are defending your team. So may you please start.
No, sorry, Chairperson. My concern goes beyond the time allocation. I accept that at your discretion you can give me more time. I'm dealing with a principal issue. I'm not dealing with time, Chairperson, with respect. I am saying to you, the initiator has made her submissions, and I'm going to respond to them. If she's given a right to reply to submissions, an unprecedented occurrence, what she might raise in submissions, I will not have an opportunity to respond to. So whether I have 45 minutes now or 30 or 2 days is of no moment, because my concern is not a timing issue. It's an issue of you do not make submissions and reply as a matter of principle. And that's the concern I'm dealing with, Chair, with respect.
Thank you, Advocate. You can advise so that I don't deprive you anything. If you want to maybe respond to what she has responded, you may do so, because I think your concern is that I shouldn't have given her, but according to my schedule, that's how the program should run. So if ever you have got something to say, because yours is to deal with your closing arguments, and in that order, you may add what you wanted to add, because the platform is open for you now.
Thank you, Chairperson. I don't want to belabor the point, perhaps in assisting the Chair in making a finding in this respect, because I feel very strongly about it, I must say. If you have regard to number 5, to the schedule, to the rules, it says what the initiator may do at this point. And it merely says she may address the committee, including on sanction, and that is what she has done. And then it says we have a right to respond to it, and that's what we intend to do. There's no provision anywhere that she can come back and have a second bite. It's not even a second bite, it will be a third one, because again, unprecedented, she's been allowed to address the committee again on 2 occasions. It's just unprecedented, it's unfathomable. And I'm asking you to make a ruling on it, Chair, in relation to the schedule that I've referred to you, which is Schedule 5 specifically, and then direct me as to where the initiator has that right. With that being said, Chair, you can start my time.
Advocate, let me allow my legal team to advise, and I don't dispute that, but what I was saying or asking from your good self is whether you want also to respond to what she has responded. If you may clarify me on that, because already she has been given that opportunity to do so. And moving forward, so that if that should not be allowed, we correct it. I don't want you at the end of the day to say that the processes were not unfolding properly. I'm giving you that opportunity.
Sorry,
Advocate.
Chair. Sorry, Chair. I'm sorry for
Yes.
interrupting. I'm really sorry. Chair, can you stand down for just 5 minutes so that your legal team can advise you on this issue?
Yes, thank you. Let's wait for 5 minutes and then we'll come back with due respect. Thank you.
Recording stopped.
Honorable members, our legal team, we are back.
Recording in
will-
progress.
I will request my legal team to give an advice and then we move. Thank you.
Chair, what seemed to be a dispute has now been resolved. Advocate Golden will not come back for a second bite. When Advocate Siboto is finished, then the matter will be set down and members will then come back and deliberate, Chair. And that's the end of the matter, Chair.
Advocate, are you okay? She won't come back and I won't give you any time. Those reservations won't be accommodated in this platform. She has exhausted 30 minutes. So can we proceed in that order?
Thank you, Chairperson, and I'm grateful for the resolution. It gives me comfort. Thank you, Chair. With that being said, Chairperson, I want to address this committee on three themes, in essence, as to the general principles that apply to such disputes, and secondly, then I'll deal with the charges in relation to each of the members. And I have raised issues before. I don't want to restate them. I just want to record them that this committee, we persist, is not properly constituted. Not because the rules don't provide for it. Of course they do. The argument is more nuanced. The argument is the rules should not provide for this procedure in this manner. And we are saying we accept it's a multi-party committee, but what you cannot disregard is the fact that it is ANC-led. So if the ANC has got a political position and a political agenda against their political opponents, it is easy to see why a reasonable person would think that they will not get a fair hearing, which is why we then had asked, as we do in Part B, which will be held in January, that at least the chairperson of this community is not affiliated to a political party. And we're saying, look at this principle and proposition from a practical point of view of litigation. If this chairperson went in front of a judge as an ANC member, and the judge is a DA member, can you say reasonably you get a fair trial? As to whether you get it or not is besides the point. It's a principal issue of perception of bias, which in itself is enough to have a judge recused. We're saying the same principle should apply here. So we're not saying you're not properly constituted because the rules don't allow it, because I get a sense that there's a misunderstanding of our submission. We're saying as a principal issue, you shouldn't be allowed to constitute as you do. You get in our courts challenges of this nature on the daily, where the rules permit for something, be it be administratively, be it be at ESCOM, be it be at N1D, NYDA, wherever it is, where the rules permit for something, and then there's a challenge to say, though the rules permit for it, they are unconstitutional rules because of these challenges. And that's the sum total of our submission. We equally say, you cannot have in a constitutional democracy an individual who advises this parliament being a witness to the case of this parliament. I mean, it's just, you can't countenance that, because that person is the same person who will then advise this very committee and this very parliament as to whether these charges should stick or not. I mean, it's just uncountenance. You can't countenance that. Mr. Glasso advises this parliament. He comes and testifies on how he perceives this matter, and then ultimately you have to take his advice as to whether he's right or wrong. Just at a conceptual level, it's completely untenable, which is precisely why we'd invited this House to pend its decision until the court rules on the matter. The perception of bias is palpable and you can't escape it, best as you may try. We say there are three primary defenses. The first is that the charges stem from unfairness of the decisions that were made by the speaker. We're saying she inconsistently applied her own rules, and that is clear from the evidence we led yesterday. Where on the one hand, she sanctioned someone for speaking after she had ruled she had ruled no points of order, when in fact, members of the ANC raised points of orders after she had made the rulings. On what basis then do you say Mr. Ceza, for example, must be kicked out of the House because he raised a point of order after there was such a ruling? Worse still in his case, because he was not even allowed to raise one point of order. It can't be that he was asked to leave because he raised a point of order, when in fact the chair did not even know what he had in mind. Not once did he speak on the recognition of the speaker. On what basis does the speaker say he must not speak if the speaker does not even know what the point of order is? Well, we know why she said that. Because your people have been causing disruption. The inescapable conclusion you must draw, best as the initiator tried to persuade you otherwise, she was referring to the EFF members. You can't escape that fact. And the difficulty that the initiator faces is that there's case law that says you can't adopt that attitude as the speaker. Why? Because they are individual members of this parliament in their own right. They are not EFF members. To then decide you're not going to give a particular person a right to raise a point of order on the basis of being an AFF member is an unlawful decision in itself. That is precisely what she has done. Simply because Mr. Ceza comes from the EFF, she decided on the basis of the conduct of previous EFF members, she's not going to allow the point of order. That is the problem here. And that you cannot escape as this committee if you earnestly take your jobs of being independent decision makers seriously. The further difficulty we face is that the Deputy Chief Whip of the ANC is a witness to these charges. She herself was implicated in these charges in that she got preferential treatment from the speaker. We've led that evidence. What do we have? The same person being a decision maker in this committee. When she herself is implicated, of course, then she's got an interest to find against my members. And more tellingly, she, before these proceedings conclude, gives a view of what her decision is. Before I even make submissions, yesterday already, she told us what her decision is. Countenance a position where you as a speaker, personally, you as a chairperson, you go to court and there's a matter that you're involved in. Before the proceedings conclude, the judge says, I take the view that you're wrong. You're not done with your submissions or evidence, and then the court expresses a view about what the outcome should be. Can we genuinely say this committee will apply its mind independently against my members, or will they follow political line of dealing with EFF members, quote unquote? I'm inviting you to earnestly apply your minds to that proposition. Let us deal with the question of Mr. Lamola, because he was a dramatis personae, if you will, in that the distinction is sought to be drawn between the conduct of Mr. Ceza and Mr. Lamola by suggesting that Mr. Lamola retracted when he was invited to. That's not the point. Mr. Ceza is being charged with speaking out of turn. That's the charge. Mr. Lamola spoke out of turn. He did not speak to any of the questions that were listed for the agenda on the day. He was nonetheless excused. On what basis was he excused if he too spoke out of turn? That he retracted is of no moment if the charge is you spoke out of turn. Fact of the matter, he spoke out of turn about subject matter that had nothing to do with the six questions, and it was not such a point of order that sought to regulate the processes of the House on the day. He was disparaging a member of parliament. He sought to ridicule a member of parliament. He improperly used the platform to ridicule a member of parliament. There is no sanction whatsoever. Then there was a discussion about the concept of engagement. Mr. Ceza testified that I engaged, or rather Mr. Malema was engaging the speaker. A technical analysis of the term was then adopted. Rather remarkably, What you typically have is an expert witness on language as evidence before any decision maker. What would have happened is, in the ordinary course, if their view is his understanding of engagement is misplaced and there's a dispute about language, an expert on language would have been called. But what do we have? We have the initiator who takes the evidence of her own junior as to what interpretation you must give to the word. How do you not see why the junior would have an interest on a certain interpretation instead of the other? He says, I use the word engagement as a translation for a Xhosa word, which I ordinarily would have used, which is bayathetha. Ukuthetha is Xhosa, he continues to submit, simply means the one is addressing the other to engage. That is his interpretation of the use of the word engagement. No, that's not the debate we're having. What are we having? What does it technically mean? Well, does it matter what it technically means, or does it matter what he actually intended to convey? You will make a finding on that. Remarkably, we are also told in the proceedings, which are unrelated to this, but Mr. Shibambe is also being charged. Let me not go there because then I'm introducing evidence from the bar. The point I simply seek to make is, it is clear by all indications that this process is a process that merely complies with the rules rather than seek to earnestly engage with the subject matter. We are in a rubber stamping exercise. Dlagute MP has suggested that already. And the fact that the witness of this committee is the advisor to this very same parliament gives credence to that submission with respect. Let me deal with Mente MP specifically. We have established that the chairperson does not have a right but a duty. In other words, she can't opt out of it. To apply the rules consistently and fairly. That is not in dispute. That was Mr. Klaso's own evidence. We've established that. What that means is, in similarly placed set of facts, the same conclusion must follow. Because if it doesn't, where you relax the rule at your discretion, as Mr. Klaso was as pains to have us believe, and then on the other, at your discretion, you apply the exact opposite, that to me suggests you don't take the rule seriously itself, except for instances where you want to target particular individuals and suddenly you invoke the rule. There's just simply no basis with respect that the speaker came to a different conclusion in respect of Mr. Lomo vis-a-vis Ms. Mente. It's just, the point I simply seek to make, committee, is this. Mr. Lomo made remarks. There is evidence that the remarks he made were of violent nature. That has not been disputed by any witness. Neither has the initiator suggested that it was not violent remarks. So you must accept that he made violent remarks. What does she do? What's the attitude towards that? She seeks to first establish whether it happened or not. She does not say withdraw. She says, Lomo, MP, did you make these remarks? He says, no, I didn't. Go have a look at the handset. What does the speaker do? The speaker reserves her ruling and says, I'll have a look at the handset. She has not to date, and she still to date has not told us what Mr. Lomo said. Neither has she attempted to find out what Mr. Lomo said. We then have 5 minutes later, Mente being accused of the exact same thing. What does the speaker do? She does not say, Mente MP, did you? In which case you'll say, I didn't. And then she says, well, similar with Lomo, I'll have a look at the handset. She doesn't do that. She does not invite her comment as to whether it's true or not. She says, withdraw immediately, without any sense of trying to establish whether she did it or not from her perspective. Withdraw immediately. What does she do in response? Speaker, what must I withdraw? The suggestion we're given is that, well, she must accept that she said it because she didn't deny it. Well, what else do you say other than what did I say? What do you deny? She's being asked to deny the claims against her. What's the claim against her? She's being accused of saying something violent. What did she say? So when you're asking her to withdraw, and in her mind she didn't say anything violent, she's asking you to look at the context and tell me what I said, that I must withdraw, and she's not presented with that, and she's being told to withdraw. She's asking, what must I withdraw? There's no answers to what she must withdraw. Then on what basis does she withdraw? The further criticism against Mente MP is that, well, at some point or the other, she must have taken steps to prove that she didn't say what she said. Well, equally, the speaker should have done what she said she would do, which is she'll go to the Hansard and show Mente MP what she said. She didn't do that. And if the speaker genuinely believes, if the initiator genuinely believes that there's something that Mente MP said that is unlawful and disparaging and violent, surely then, because Zulu MP gave a version that she heard what was being said, then why was she not called to come and tell us what Mente MP said? If Mente had an obligation to do more to disprove the charges against her, equally the speaker should have done more to prove the charge. If Zulu MP, if Mgweba MP, if other ANC MPs heard what Mente said, why are they not here to give that version so that I can cross-examine them on it? Why must we accept their version in their absence? To date, there's not even a suggestion of what Mente MP said. All we are told is she said something volatile, violent, and disrespectful and unbecoming of an MP. There's not even an attempt to at least say this is what she said, even though you don't bring Zulu MP and Mgweba MP to confirm it. At least tell us what she said. None of that is there. And on the basis of that, she still must be found guilty of having said something unbecoming before Parliament. What was she asked to deny? What was she asked to deny? What's the statement she was asked to deny or accept? What's the statement? What was she supposed to withdraw? What exactly was she being asked to withdraw? And then she's being accused of not taking this committee into its confidence and telling this committee what she had said. She's been clear from day one. It was over a year ago. I do not remember what I said. But having watched the videos, clearly I don't know what I was being accused of, which is why I asked, what must I withdraw? In the same way she did not know then what she was asked to withdraw, she does not know now a year later. How then do you say you must find an inference that suggests that she's hiding something when she herself on the very day did not know what she was being asked to withdraw? What is she going to say to this committee to say this is what I said if on the day she does not know what she's being accused of? 3 times she asked, Speaker, what must I withdraw? What does the speaker say? I'm not interested in that at the moment. That's what the speaker said. Remarkably rather, if you ask me. Because she is saying, you are asking me to withdraw a statement I have no knowledge of. And then she's engaging the speaker on that basis. The speaker says, I do not care about that, but I'll make my ruling. What does Mr. Koso have us believe? It is appropriate for a speaker simply because she's got the power. If you're asking what dictatorship is to me, I will tell you this is a prototype. She is saying without any basis, rather, Mr. Koso is suggesting without any basis, simply because the speaker has the power, she may exercise it as and when she deems fit because she's got a discretion. He will have us accept that a speaker without basis can exercise her powers and no one should question it. That is what the speaker and Mr. Koso will have us believe. I accept that the speaker has a duty to maintain order. It is curtailed. She is exercising public function that is subject to the rule of law and the Constitution. What do they provide? You may not exercise them arbitrarily, and that is precisely what the speaker did. She may not exercise it unfairly, and that is what the speaker did. We are led to believe that simply because the speaker equally punished Mgweba MP, Mente should have accepted. It's as silly a proposition as suggesting that when someone is found guilty of a crime unlawfully, then the next accused must equally accept a guilty finding unlawful one simply because the person that came before them was subjected to the same unlawfulness. I say no more about that argument. And then another criticism that's leveled against Mentor MP is that she spoke without being recognized. She did not raise a point of order, rather. Well, this is quite remarkable because when you look at the video itself, the speaker asks Mentor MP to stand up. She stands up. The speaker asks her to withdraw. She raises a point of order. Chair, you can't kick me out if you don't tell me what it is that I must withdraw. At that point, she's raising a point of order. She's told, you did not raise a point of order. Well, let's countenance what the proposition means. It means Mentor, in the course of the speaker addressing her, should have sat down and said, Speaker, point of order, be recognized, and then say, Speaker, what did I say wrong? That's the sum total of the submission. She was already on her feet raising the point of order. On what basis then do you say she spoke without raising a point of order if she was standing and addressing the speaker on the invitation of the speaker? I submit it's a ludicrous proposition. We have drawn your attention and we're happy to send out a useful spreadsheet that my attorney has put together for me. It's about 5, 6, 7 pages of instances where members spoke out of turn, including instances where they spoke after the speaker said they may not address the court. If the committee is interested in that spreadsheet, I'm more than happy to share it. There's this crafty attempt, and I say this with respect, to style the charge against my clients as causing disturbance and volatile exchange, or they engage in such. That is not the reason the speaker kicked out the members. What was the reason? It's the reason that appears in the Hansard. What was that reason? Honorable Mende, you are refusing to withdraw when I tell you to withdraw. That is what the speaker was complaining about, nothing else. And this crafty charge is created to get out of the fact that the speaker actually does not know what Mentor MP said. And I say with respect, for that reason, that charge stands to fall by the wayside. I repeat, Chairperson, honorable members of this committee, that Lomo MP is no different from Mentor MP in terms of facts, and the same consequences should have followed for both of them. The reason Lomo MP is not here as a charge member is because his set of circumstances were protected by the speaker. It could well be that if he was asked to withdraw a statement that he knows the speaker did not hear, he might have well have refused. We don't know. We're simply saying he could have been in the same position where he says, Speaker, what are you asking me to withdraw? And that would have led to the same circumstance that Mentor found herself in. But he was protected from that vulnerability by the speaker, who coincidentally happened to be a member of her own party. But for Mentor being asked to withdraw a statement that the speaker has no knowledge of, then the set of circumstances that followed would not have occurred. If the speaker had said, Mentor, I do not know what you had said because you're asking what you had said, sit down and I'll refer to the Hansard, then she would not have had to defy the speaker by not leaving the house. It is that unfairness of treatment that has necessitated and led and set up Mentor MP to disregard the ruling of the speaker. The speaker created that fertile ground for Mentor MP. To this day, we do not know why Zulu and Mkweba were not asked to confirm what they heard. To this day, this committee is being asked to accept that Mentor said something unbecoming when it could have been so easy to have Zulu here MP and Mkweba MP tell us what exactly she had said. You must draw an inference why they were not called. Let me deal with Ceza. We say in respect of Ceza MP, it is uncontested evidence. When I say uncontested, there is nothing that has been presented to this committee to gainsay his version. On the Plascon-Evans rule, you must then accept his version. His version is, when the speaker told me to leave the house, I stood up. There is no challenge to that version, with an intention of leaving the house. Why do I stop? Because Ceza, or rather, Paulson MP stands up and says, wait. Simultaneously, I can hear Malema MP address the speaker saying, but warn him. Whether he's entitled to a warning or not is not the point. It's a smoke screen rebuttal. That's not the point. Let's assume we accept he was not entitled to a warning, because that's what the debate has been about. That's not our case. Our case is not that he was entitled to a warning. Our case is that he, because Malema MP had said, you have warned other members, warn him first. He says, I then stop to see what the conclusion of that engagement is. Because I also know, firstly, the speaker said I can't speak, he allowed other people to speak. I've been told that I'm not entitled to a warning, but other people have been given warnings, and that's undisputed. Then he says, I stand to wait and see what the conclusion of this discussion will be. It could well be that the speaker will respond and say, well, now I remember I didn't warn you and I warned other members, don't leave, but don't do it again. He says that is why he stopped. No one is challenging his evidence that he stood up to walk out until Malema MP intervened, until Paulson intervened. No one is disputing that. He then says, I then stood and observed the engagements. The next thing he knows, he's being evicted out of the house by the security personnel. Why does it matter what it is that he thought? It matters because his charge relates to intentionally and willfully disobeying the speaker. You can't intentionally and willfully disrespect the speaker if what you say is that I was not defying the speaker, I simply waited until we see what the speaker says in response to Malema MP. I do not want to find myself in a position where I'm out of the house, then the speaker accepts that she didn't warn me and should have, and I'm already out of the house. If that is the case then, though strictly speaking he's not complying with the order of the speaker, he is in essence nonetheless not intentionally disrespecting the speaker. And if you can't gainsay that argument, then he can't be in breach of the charge, or rather he can't be guilty of the charge of intentionally disregarding the instruction of the speaker. You may have your own opinions, and I respectfully submit the video does not speak to itself as the initiator would suggest to you. You could watch the same video and have different interpretations. But what better interpretation than someone who's actually there and making the engagement with the security personnel? Mr. Ceza says, I actually said to the security personnel, I will leave, but just allow this engagement to go through. Listen to what Malema is saying. Listen to the response of the speaker, and if the speaker insists, then I'll walk out. He says that is what I said. If he's lying, why are those security not personnel before this committee to tell us that? On what basis do you accept a version that is untested before you? Ceza has the decency to come before this committee to give his version. We do not have the benefit of the security personnel's version in what was said, yet their version must be accepted. On what basis? I rhetorically pose the question. What we've also been misled to believe is that there was a warning given to Ceza, none exists. It's not there, it doesn't exist in the Hansard or the video or in the testimony of Mr. Klaas. So as a starting point, the speaker says, leave the house. As a starting point, there was no warning, there was no invitation for him to leave the house. We were told that he and Paulson were invited to leave the house. None of them were invited to leave the house. On what basis then do you say they failed to abide by the instruction of the speaker? There was never any instruction from the speaker for them to leave the house. With Ceza there was, and then there was this intervention. With Paulson, there was not even a request for him to leave the house. On what basis then does he disregard and disrespect an instruction of a speaker that doesn't exist? The first point of call by the Speaker in relation to Paulson was to say, you might as well leave. We are told that means, well, she was inviting him to leave. There's no grammatical support for that proposition. It was an instruction for him to leave. How then did he disrespect the Speaker if the Speaker did not ask anything of him? And if there's nothing the Speaker asked of him, then you can't find that he disregarded the instruction of the Speaker with respect. Insofar as his conduct relating to disturbing or obstructing, he's given his version, which too is uncontested. He says, I spoke to the security personnel and I told them, wait until the Speaker makes a finding. No one has been brought to tell us that is not true. When it was available for the initiator to call those security personnel, she chose not to, and I'm asking you to draw a negative inference on that stance. And I am suggesting I put the question to him because not running away from the facts. I said, no, I hear the proposition that you were engaging and you're asking them to wait, and no one is telling us that that's not actually what you said. I nonetheless invite him and I say, but how do you explain you putting out your hand? I readily accept, and I've got 7 seconds, and I promise these are the last 3 sentences, Speaker, should be done shortly. I say to him, but we see your hand being stretched out. In fact, you are pushing the personnel. You're not just having a conversation, generate weight, and issues being addressed. We're actually pushing actively. We are prepared to accept that. We're not disputing that evidence. But what is also not disputed is that, well, clearly Mr. Paulson is not a good friend of what he calls the bouncers. So ultimately, their engagements will be volatile. We accept that. It does not nonetheless change what he's saying. He's saying, I'm pushing them back because, oh, here we go again. We're going to be physically attacked. I push back not because I'm fighting back. I'm saying, no, but wait. This is what is happening in the House. No one comes and tells us, no, that is not what Paulson said. And if then Paulson genuinely was saying to the security personnel, and there's no evidence to the contrary, no, but wait, before you kick out Geza, Malema MP is on the podium, he is engaging with the Speaker. Not engaging in a sense of they're having a conversation, he's simply addressing, maybe it's a choice of word issue, but from their evidence it is clear what they're suggesting is that Malema MP is addressing the Speaker. That's what they're saying. And for that reason, wait until the Speaker responds, and if the Speaker insists on kicking out someone without a warning, though she's afforded other ones the warning, then you may proceed with your work. If that is the case, which you must accept to be the case because there's no evidence to the contrary, then on what basis do you then say he intentionally obstructed the work of Parliament, if all he meant to do was to halt the process until the Speaker responds? You can't say there was an intention. And this is not a new argument that I'm springing up at the last minute so I can catch anyone out. I was decent enough to put the proposition to Mr. Glass. I said, Mr. Glass, do you know the test for contempt of Parliament? He refused to answer my question because I wanted to engage them on this very issue, that there's no evidence to show that Geza MP and Paulson MP intentionally disobeyed the instructions of the Speaker. And absent that, with respect, I suggest...
Advocate, your time is up.
My time
I
is
may
up
give
and
you
I'm
2
wrapping
minutes
up.
to wrap up.
Yes, thank you
Yes,
very much,
wrap
Speaker.
up.
That was literally the last sentence, and I thank you for it, Chair. All I'm simply saying, absent evidence of an intention on their part, then you can't find them guilty of any of the charges. And I think that is the entirety of my submissions, and I'm grateful for the indulgence, Speaker. And I thank you, Initiator, as well, and the members of this Parliament, of this committee. Thank you.
Thank you, Advocate. Thank you so much. Honorable members, here we are. I will now allow members of the committee 15 minutes to ask clarity-seeking questions to the legal representative of the affected members. We have got only 15 minutes. Thank you.
Two hands are up, Chair. Mr. Mlenzana and the Deputy Chief Whip.
Honorable Mlenzana, the stage is yours. And Honorable Deputy Chief Whip after that, please.
Thanks, Chairperson, and thanks, Advocate, for your articulation. Perhaps, Chairperson, I would have made this disclaimer during the course of the week for advocate to understand that, look, advocate, I am not a legal person. I'm only a labor law person. Hence, then, some legal interpretations and wording may not be in sync. This is just by way, Chairperson, of introducing my one question and comment. The question is, advocate, it's a clarity-seeking question. Are you disputing fact as tabled in the various charge sheets, or are you justifying action by your clients, which is a mitigation in a sense? I would want you to go further in explaining that one. Then, just to check, because even today you are mentioning that there has been some conceived mentality by some members of the community that your clients are guilty as charged, whilst we're still continuing with a hearing. Just to check for correctness and assistance going forward, we are learning, advocate. If one says, I put to you, which means I suggest, as informed by what occurred, or as informed by witness, or as informed by the action as seen in the video clips, would you then advise your clients not to rebut or not to respond, or to take a view of saying there is no comment? If then that is the case, wouldn't such be tantamount to choosing the route of silence, which then silence means consent? I'm thinking aloud to be guided by you, advocate. Thanks, Chairperson.
Thank you, Honorable Mlenzana. Honorable Deputy Chief Whip.
Thank you very much, Honorable Chairperson. Good morning to you, my colleagues, and the initiator, the affected members, and advocate. Advocate, I want to know, in your view, is it wrong for Parliament to have its own rules which guides its proceedings? Because from where I'm sitting, all institutions, even in our own homes, we do have rules. So, in this regard, is it wrong for Parliament to have its own rules to guide its own proceedings? Number two, is it wrong for Parliament, in your own view, to have a committee that deals with its own internal matters? Because my own understanding is that before you can go outside, you must have done something inside. You must do your own internal processes before you can even go to court. So is it wrong for Parliament to have a committee that deals with that? Thank you very much, Honorable Chair.
Thank you, Honorable Deputy Chief Whip. Advocate, can you respond to the two members, honorable members?
Chair, may I please come in before
Okay,
the
thank you,
advocate?
Honorable Chapa. They didn't inform me that your hand is up. I'm sorry for that.
No,
You may take the floor, please.
No, thanks for the opportunity, Chair. let me also agree that I might not know much about law except hearing here and there and making my own understandings, but we are here also to learn. Chair, the advocate spoke about the composition of this committee, that he doesn't dispute and make whatever inferences or suggestions that he made, that how it must be constituted. I just want to make it a point, Chair, that the problem here, we are a multi-party committee, and the minute you start to make sure that you remove members of the ANC or members of the DA or members of the EFF from a committee, you will have a challenge, because according to the rules, these committees are formulated as you see them. So it is okay that it can be argued somewhere else, but here we must not be seen, or members of this committee must not be isolated as per their organization. And that must be something that we should emphasize on this platform, Chair. Two is that there has been an issue about the speaker not coming to testify and everything, especially on the issue of Honorable Paulson. Honorable Paulson said with his own mouth, when the speaker said your people, he speculates that the speaker meant the EFF members. It was not the speaker who said his people are the EFF members. What if he meant everybody in the house as your people, because you are all members of the National Assembly? It's something that was a speculation. I asked Honorable Paulson, were the members of the EFF unruly? Were they disorderly? Were they distracting? He never responded to that question. Now, it cannot be a matter now that is brought before us that the speaker meant the EFF members. It was a speculation, according to that person, that he said your people are distracting me. The last point from me, Chair, is this one here. The member listening to the intervention before he goes out. The speaker orders you to go out, leave the house. And then another member intervenes, stretches his arms. Let's listen to what Honorable Malema is saying and how will the speaker respond. After an order has been made, according to the rules of parliament, when the speaker has made a ruling, it has to be obeyed. Now, the initiator has been on record many times asking these members, do you listen to the speaker or do you prefer to listen to the commander-in-chief of the EFF, like they called Honorable Malema? I never had clarity on this one. So it cannot be correct, Chair, that we want to say there was an intervention that has to be listened to once an order was made. And all of us as members of parliament, we had to abide. So it cannot be, for me, it doesn't hold water. When the speaker has ordered and now you want to listen for another member that wants to intervene, the speaker has made an order. As it has been said, according to the rules, you know if you're not satisfied about that order, there are channels to be followed. Thank you, Chair.
Thank you, Dr. Tape. Is there any other hand so that I don't commit another mistake? No, any other hand?
We don't have hands now, Chair.
If so, pardon?
We don't have any
No.
hands now, Chair.
Okay, thank you. If there are no any other hands, I will now invite advocate to respond. Thank you.
Thank you very much, Chairperson, and I thank the members of the committee for their questions. They're really useful in terms of us trying to get to where we're trying to get to as the charged members. The first ones came from Utatum Lenzan, and the first question he asked me is, am I disputing the facts as per the charge sheet? Well, I wouldn't call them facts, precisely because we say they're not facts. What is in the charge sheet, by the way, is not facts, it's charges of claims of what happened. What fact is what is in the Hansard. And I suppose then in answering your question, we're saying in as much as we all see the same video, you don't have a full context of every nuance of the video if you are not there. One case in point is a question of whether Paulson and Geza actually said to the protection services, let's wait and hear what the outcome will be. No one has said that didn't happen, though we're all watching the video. So introducing a new dynamic of fact with that evidence. And let me just deal up front with this misnotion of the members chose to listen to Malema MP instead of the speaker. That's not what they're saying. They are saying it could have been anyone saying, you didn't warn this member. Please give us an answer to that proposition. They then say, we then waited to see what the speaker will say in response. Malema MP did not say, don't leave the house, and then they didn't leave the house. Because then your proposition stands if you're saying they're listening to the CIC, quote unquote. Malema did not say stay in the house. In fact, he was not even addressing them, so how are they possibly listening to him? Malema MP is inviting the speaker to apply her mind and say, is it fair to not warn this member when you've warned other ones? They say we hear this voice now. It could have been Dlagute MP raising the point that you didn't warn these members. They still would have stayed in the house until the speaker responds. So I hope I've clarified that misnotion. The second question I've been asked by Utatum Lenzana is if I would suggest and inform my clients to not comment to certain questions. I'm trying to suss out what the idea is because I want to answer the question honestly. I'm trying to get the crux of the question. And I think that Umlenzan, you'll correct me if I'm wrong, it's going towards my members not answering questions around the interpretation of the rule. Where the question is put to them, no, but if you don't listen to the speaker, then you're in breach of the rule and therefore you're guilty. I will confess now that was my advice to them. I said the interpretation of the rule is a legal question. You have been called before the committee to answer factual claims. It is not for you to tell us what the rules mean and what you're guilty of. Because if that's the case, then I'm obsolete. I'm here for no reason. That's my part of the job to say when you interpret the rule, this is the conclusion you reach. So I said to them, don't do my job for me by giving interpretation of the rules and accepting that you didn't listen to the speaker, therefore you're guilty. That's what I'm here for. It's for that reason they didn't answer those questions. And I hope that is not held against them because they're acting on my advice. Dlagute MP then posed the following questions to me. Is it wrong for Parliament to have its own rules? Of course not. Of course not. You must have rules to run the House. That's not our contention either. Our contention is that the rules that you've come up with are unconstitutional. Let me draw your attention to the issue of the erstwhile president of the country, Mr. Jacob Zuma, where there was a debate around how you discipline him, whether motions of no confidence require fact-finding. The Parliament did not have rules, and to the extent they did, they were not adequate. The rules exist. That wasn't the problem. The reason the court found the way it did was to say, notwithstanding you having the rules, they're not constitutionally compliant. So it was not wrong to have the rules in relation to the removal or impeachment of a president, but the court says they're inadequate or they're not constitutionally compliant. It's the same submission we're making here. So there's nothing magical that we're trying to suggest to this committee. We're simply saying the same way the court found against your rules then, which you're entitled to, we're inviting the court to do the same now. The fact that you have rules does not mean they are infallible. We are suggesting, as a matter of fact, that these ones in particular are fallible. You then asked me a second question. And just by the way, by way of illustration, it's the same thing that happened with the Phala investigation. A system was put in place because you can't have a sitting president who appoints at his whim members of cabinet being subjected to the same people in terms of investigating him. That is why you then have an independent panel to fact find. Why? They're trying to avoid the same problem we have in this committee, where you've got people who serve at the whim of the president having to make decisions about the president. Similarly here, you've got people who are members of the ANC having to accuse their leader being the speaker, coming from the same party, it's unfathomable that you'd expect that politicians would criticize their own who's the head of this parliament. That is the perception we're trying to curb against. We do not expect you, politically speaking, not legally, to find against your own speaker. We don't expect that. And that is the problem with the process we have, which is why we then suggest whoever is going to make a decision about whether my members are guilty or not must be someone who's independent and not beholden to their political principle. Then Klape MP asked me the following question. The composition of this committee is a multi-party committee. Again, it's a misdirection to suggest that we suggest otherwise. We are simply saying, in as much as it is a multi-party committee, what you can't deny is that decisions of the majority of this committee will stand. Who's the majority? It's the ANC members. What perception does that create? It creates a perception where politically decisions will be made to deal and deal, quote unquote, with the members of the opposition. We're not suggesting that ANC members must leave the committee. We're saying, in fact, it would be unlawful for you to remove them. Why? Because the constitution and the rules say they must be there. That is not our fight. We're not suggesting that for some reason here, then you must have equal number of EFF members. That's not what you're saying. We're saying the fact that the rules then create that scenario where the majority is ANC members and they make the decisions is the problem. So we're not saying you should have done it otherwise. We're not saying someone is here who shouldn't be. We're saying please wait for the court process at Part B to see if they agree with our proposition. That perhaps, even though you've got a majority part in the committee, maybe what would be appropriate though, so that there's not perception of bias, that the ultimate decision maker as to whether they're guilty or not should be an independent person. That is what we're suggesting. We're not suggesting you should have done anything different. We are just saying, please wait for the process to see if the court will not agree with us on that score. And if we are wrong, then you can make the findings against our members. We're not saying retract anything. We're saying, let's stop at this point. You still can, where you don't make a decision, you wait for the Part B, and after the court has said to us, no, you are wrong on the propositions, then you can make your findings. That is all we are suggesting, and I hope that has put that argument to bed. There are two more questions which I'll try and answer very quickly. The last question from Klape MP is, Nazir Paulson MP speculated about what the speaker meant when she said, your people. That question and that proposition really concerns me. And it really then delineates the same problem that I've been complaining about the entire time. Whether members of this committee, particularly ANC members, can really rationally apply their minds to the subject matter before them. To suggest with respect, Lagude MP, that she was not talking about EFF members is just untenable. Then who could she have been talking about? When she said, your people, look at the context of the video and what the issues were. If you're going to suggest to me that Nazir Paulson is speculating, which he was, of course, but is it an unreasonable speculation? And if you're suggesting that the speaker was not talking about the EFF members, when she was talking an EFF member saying your people, if you're suggesting to me she was talking about someone else, who? Who was she talking about? And that's the difficulty, because now you have not called the speaker to answer that question. This is exactly what I'm saying. You yourselves don't have the benefit of who the speaker was talking about. Why? Because you refuse to call the speaker. And when you are seized with having to draw reasonable inferences, you are suggesting that she wasn't talking about the EFF, then who was she talking about? The last point. I've dealt with the last point, Chairperson. I think I've exhausted all the questions that were put to me. To the extent I didn't answer one, or not to the satisfaction of the committee members, I'm going to allow them to ask them. And if not, thank you so much, Chairperson.
Thank you, Advocate. I will establish that from members. Members, if there is any omission, I'm giving you a second bite and also a follow-up question. Those who feel they were not answered up to satisfactory. Can you show by a raise of hand anyone to have a second bite and anyone who have to make a follow-up? Over to you, Honorable Member.
There are no hands, Chair.
Are there any hands from honorable members?
No hands, Chair.
If there are no hands,
Chairperson,
Mr. Mlenzana has
Yes.
just come up.
Lenzana,
honorable
yeah,
member.
I'm very
Yes,
sorry
yes.
for this. I'm battling with my gadget. Age is
All right.
taking its own toll.
Okay.
Can I come in?
Yes, may come in.
Thanks, Chairperson. Thanks, Chairperson. Thanks, Chairperson. Just one thing which slept as I was drafting my questions, it was in another gadget. It's an additional question which I didn't ask. I listened to the advocate when articulating the justification for the negation of cause of the rules and disregard by his clients from what the speaker was saying. And a question was striking my mind as to whether do we as committee have to choose legal terms in terms of their political affiliation or we have to, as a multi-party committee, also be multi-party in choosing our legal teams. You know, would he, for instance, agree if I, as a member of this committee, would then allege that advocate is actually an EFF member, or because look, sitting here, one would think that we have to respect his profession, and he is here based on his profession, not on terms of affiliation. So if advocate could clarify this notion, which is actually trying to be instilled in us, of being party political in terms of thinking and in terms of choosing our representatives. Thanks, Chairperson.
Thank you, Honorable Menzana. Advocates, can you respond?
Thank you, Chairperson. And abulela Tata Mlenzana umbuzo wakho, and it's an important one. I don't want to misdirect this committee by suggesting that this is a question before you. The question before you is not the composition of this committee. I was making the point just to illustrate the point that is underlying what I was submitting to you. You don't have to decide whether you're properly composed or not. You don't have to decide who you can appoint as legal advisors. You don't have to decide whether your legal advisors can be witnesses who then come and tell you whether their own evidence is credible or not. I'm not asking you to make that determination. We're going to have that debate at Part B, which is next year. So do not, please, I invite you, Dr. Mlenzana, do not concern yourself with that debate. I'll answer the question anyway. What you have to deal with are the charges as reflected in the charge sheet. Charge 1, willful disobedience of the speaker. You must answer the question as a matter of fact, whether it happened, and as a matter of law, whether it happened, and therefore whether they're guilty or not. That's all you have to answer in respect of all three. Whether now, because I've been invited to comment, well, would there be a problem if I was an EFF member? Well, firstly, I'll confirm I'm not an EFF member, neither have I been one before. And as a matter of fact, advocates are not allowed to have political affiliation to their clients. Why? This exact problem we're complaining about here. That once you cannot bear an independent mind to a dispute, then the reasonable perception is that you're going to drive an agenda. In blunt terms, that is exactly what I'm suggesting this committee is doing. The reason a judge cannot have political affiliation is because when they're seized with a decision as to whether someone is guilty of something or not, there's a reasonable apprehension that they will make a decision on a biased basis relative to their political affiliation. We then say it is for that reason We're saying that this committee must wait and see if the court agrees with us. We are suggesting you can't have a committee that is ANC-led, chaired by an ANC member, deciding whether their political opponents are guilty or not. I'm not saying you shouldn't do it because the rules don't allow it. Of course they allow it. We're saying it's your rules that allow it. The fact that you made those rules to favor this exact scenario is the problem. And we're saying we're bringing that challenge, and that will be dealt with at Part B in Jan. And I hope I've answered that question. Thank you, Chair.
Thank you, advocates, honorable members. We're supposed to have gone to tea break at 11:30. Let's take that tea break and then we'll resume after 15 minutes. Thank you.
Recording stopped. Recording in progress.
Honorable members and our legal team, we may resume our duties. Honorable members and our legal rep and our officials, the initiator and the legal representative of the affected members have presented their evidence by way of a video footage of the 30th August 2022 incident and the testimony of the Secretary to the National Assembly, Mr. Kaso. We have just heard closing arguments from both sides. It is now the time for us to deliberate on the evidence presented and to make findings on whether the affected members are guilty as charged. If the members are found not guilty, it is the end of the matter, and we will then table a report to the House to that effect. If, however, they are found guilty, we'll then proceed to the next step. Just to recap, in a very summarized form, honorable members, the affected members are charged for having deliberately created and took part in a serious disturbance, disorder, and disruption in the House, and acted in a way which was seriously detrimental to the dignity, decorum, and orderly procedure of the House. Before we proceed to deliberations on the evidence, I will suspend proceedings for about 30 minutes to allow members to consult in private amongst themselves. The proceedings are therefore suspended for 30 minutes, members. Thank you.
Recording stopped. Recording in progress. Recording stopped.
Honorable members, our legal team,
Recording
as
in
well as our
progress.
officials, let's resume with our duty. Honorable members, let us resume the proceeding. I'm now requesting you
Chair,
to participate,
excuse me,
make
Chair.
your inputs.
Excuse me, Chair, we're just waiting for the legal team of the EFF.
Okay, thank you, Initiator.
Chairperson, we can resume now. The legal teams are both here.
Thank you. Let us resume the proceedings. The floor is open for your inputs, honorable members, as indicated earlier on. I'm now inviting hands.
Dr. Lotrit, hands is up.
Yes. And who else? That's the only hand.
And Mr. Mlenzana.
Who else?
We also have the Deputy Chief Whip of the Majority Party and Dr. Tlape, Chair. Thank you.
Okay. And who else?
That's the lineup for now, Chair.
Thank you. I now invite Honorable Dr. Ludwig to make some inputs. Over to you, Honorable Member.
Thank you very much, Chairperson, and I hope that I'm audible and that my connection is okay.
You are
Chairperson,
audible.
thank you, Chair. Chairperson, I first want to address the whole matter of, and I know that the advocate for the affected members said that this is not our concern, but that still to me is something that I would just like to mention, is that even though the matter of the composition of this particular committee will be heard next year before the court, I think it is important for us to understand that even though the matter will be before the court, that our rules as they are not suspended, neither is the application, and I would at no point want us to be inhibited in exercising our duties as members of this committee because there is a pending court matter. Secondly, Chairperson, I think that when we look at the charges and the evidence we have heard and which has been presented, there is, to my mind, one crisp question, and that is whether there was indeed contempt of Parliament in that an instruction by the Speaker was willfully, deliberately ignored
or refuse to. And Chairperson, if I look at the evidence that has been led, the video we have seen, and I want to add here that what gave rise to the instruction by the Speaker is another matter. The Speaker, in terms of the Powers and Privileges Act, in terms of the parliamentary rules, has the authority to issue an instruction. And if one refuses to obey that instruction, to my mind, one is in contempt of the rules of Parliament. And what then happens if one refuses to leave when instructed to do so, it does cause a disturbance and a delay, and also prevents members from exercising their constitutional and legal rights in terms of procedure. So it does have an effect on the decorum of the House. As I said earlier, it is important to note that it is about whether there was a willful and intentional refusal of an instruction, which to my mind was very clear that the affected members did not obey or adhere to the instruction. The question of what gave rise to it, I think, is perhaps an argument for mitigation if the affected members are found guilty of the charges against them. But I think we should answer that question. And to my mind, there was intentional, willful refusal of a clear instruction by the Speaker. And therefore, I believe that the affected members should be found guilty of those particular charges. So, Chairperson, that is from my side. And I also want to add, perhaps, that any member, if you are not, in terms of our rules, not happy with the instruction, the ruling of a presiding officer, be it the Speaker or one of the chairpersons, the remedy is that you can approach a presiding officer, you can write to the Speaker or the Deputy Speaker and request that the ruling be referred to the Rules Committee. Now, to my mind, I don't think we have been presented by the affected members in any way exhausting these internal remedies. So therefore, I believe that they should be found guilty, and they did not, for some reason, use the internal remedies. Thank you.
Thank you, Honorable Dr. Honorable Mlenza.
No, thanks, Chairperson, and for this round, I think we are still on track. Chairperson, as I indicated, I will always put this for noting that one is an ordinary, labor law person, and as such would always be cautious, particularly when we come to this stage of decision making. One, Chair, I would suggest that the committee doesn't put the three members into one bag in terms of decision making. One would have also, though I know that the second round of mitigation and otherwise would come, but correctly have also to put into circumstances which led to the action. Hence, then I would lift the question of Honorable Mente to such that when one gets into the decision as to whether one is found guilty or not, there would then be circumstances to the verdict. One wouldn't say, Chairperson, yes, Honorable Mente was correct. But then, if you listen and watch, there are some gaps which would then suggest that for me, we as the committee begin to apply our minds and say a way of dealing with her case be separated to the other two members. Because these other two members, correctly as my colleague Dr. Lutrent has just alluded to, when she was, dealing or explaining or articulating on contempt, it is clear that the two honorable members are guilty as charged. I will pause there, Chairperson. If at some stage you would require me to come back into the question of Honorable Mente, I will be in your hands, Chairperson. Thank you.
Thank you, Honorable Mlenzana, for your inputs. Honorable Deputy Chief Whip.
Thank you very much, Honorable Chairperson. Honorable Chairperson, without repeating what the Honorable Lordship and Honorable Mlenzana said, I just want to emphasize on the point that Parliament, like any other institution, have its own internal processes. It has its own rules, which guides the proceedings of its houses. So it cannot be that Parliament as an institution, its rules for proceedings are disregarded by members who are supposed to be called honorable members, who are supposed to uphold the decorum of the House. So by so saying, Honorable Chairperson, on that very same day, even though we are being accused of being biased and everything, we are a committee of Parliament, like any other institution which have their own committees that deals with unruly behavior, that deals with anything that goes against the rules that are there for that institution or for those institutions in order to function and operate smoothly without being interrupted or disrupted by anything. So by so saying, Honorable Chairperson, we heard what the initiator said, and also before the presentation by our initiator and that of the advocate of the affected members, there was also evidence that was led before us as a committee. And also we have seen the video footage that was shown to us and the evidence that was led by Mr. Paso. So looking at the video footage and also checking on the Hansard, I would say that, Honorable Chair, that the behavior of Honorable Keza and Honorable Paulson was unaccepted, Honorable Chairperson. They disrupted the House with their behavior, and that is not what is expected of members of Parliament to do. Even in our own houses, Honorable Chairperson, our own homes, we have rules that our kids and all of us follow in our own homes. So as leaders and members of Parliament, we are expected to uphold the dignity and the decorum of the House. What we do in that House, which is at the glare of the world and the nation at large, should be a conduct that is acceptable, not a conduct that will make our society and the community at large to emulate what we are doing and think that what we are doing because some of them see us as their role models. So they will do what we are doing thinking that is right, but it's not right. So As whips, we have a responsibility to make sure that our conduct is that which is accepted in the House as per the rules. So the behavior of Honorable Paulson and Honorable Keza was unbecoming in that House. It's there on the video, it's there on Hansard, it's there also in the evidence that was led in before this committee. So, Honorable Chairperson, these two members has grossly disrespected or disorganized the House on that day. They know the rules. You cannot, the business of the day on that day was questions to the president, of which the questions are lined up from question 1 up to question 6. But they chose, because their intention was to disrupt the House, they chose to come to the House and decide to jump all the questions and jump to question 5, which was question 5, instead of following the proceedings of the House. That was their intention. Honorable Keza spoke unrecognized to ask the question, unrecognized, disregarding even the caution that was given to him. And so did Honorable Paulson, to prevent and to disrupt the proceeding of the House, and also prevent the Parliamentary Protection Services when they were called by the Speaker to come and remove those members who were supposed to be removed from the House. So that is a behavior that is uncalled for. When it comes to Honorable Mente, I think she has advanced her mitigation, and looking at the video and also listening to listening to the video footage, and also going to Hansard, I think there, Honorable Chairperson, there is nothing that we found that she has said, Honorable Mente, in that House. We heard the Speaker reprimanding them, and also Honorable Zomo to Honorable Zomo to say that she will come back with she will go and consult Hansard. Then Honorable Mkweba withdrew. Then Honorable Mente asked, what is it that I said? We found nothing on the video and also on Hansard. There is nothing that we found for that Honorable Mente said in that on that day. So I, in my view, I think I will not find Honorable Mente to be guilty, because there was nothing there. But as a whip, I think I cannot go without saying this. She has a responsibility to make sure that her members, irrespective of whether she agrees with the ruling of the Speaker or not, she's a whip. She knows what it is that she must do, even if she doesn't agree with the ruling of the presiding officer of that or that of the Speaker. Her tone on that day, and also during this hearing, there was a time when a tone was not acceptable. So I just want to caution in that regard that as leaders, we must always be at our best behavior, irrespective of what. When we are not in agreement with anything that has been said or the ruling, we know the processes. We must follow the processes. There is no harm in doing so. So, Honorable Chairperson, I think this is my my presentation. Thank you.
Thank you, Honorable Deputy Chief Whip of the Majority. Honorable Dr. Tlhape.
Thank you, Chair, and thanks for the opportunity once more. Chair, the honorable members that spoke before me has said a mouthful in terms of the procedures, the rules in Parliament, and why we're here. Based on what has been presented, what we have seen, what we have heard, what the members has testified and the witnesses, Chair, I would want to agree that even from my side, I couldn't find evidence enough that support the charges against Honorable Mente. It is very interesting, though, for me that she does not even remember herself what she said. But the fact of the matter is that there's nothing that we could say as this committee, this is what she said, and this is why she needed to be reprimanded. So it will also be my submission, Chair, that she be alienated from the other two members, or these charges against her be withdrawn, or I wouldn't find her guilty in this instance. As for the other two members, Chair, I would agree with my honorable members that the members has got a case to answer, and as such, I would support the charges that has been put before them. Thanks, Chair.
Thank you, Dr. Tlhape. Do you still have any other hands, honorable members?
There are no more hands, Chair.
Pardon? No more hands.
Yes.
Okay, thank you, honorable members, for your deliberation. The findings of the committee are that
sorry.
honorable cause. Yes?
I saw Mr. Mlenzana's hand was up. But
Yes,
he
yes,
lowered
Chair.
it.
As I indicated, that if Chair allows, I would come back, but I am in her hands.
Yes, you may come back, please.
Thanks, Honorable Chairperson. What I wanted to raise as I come back would be, particularly as I said, in case of Honorable Mente, it should be put on record that this committee remains a multi-party committee, and at no stage would we yield to any type of provocation which would then make us unable to decipher fact. Hence, then, I also fully concur with my colleagues that let us formally withdraw the charges from her without even the level of her going to mitigation. Thanks, Chairperson.
Thank you, Honorable Mlenzana. Honorable members, the findings of the committee are that Honorable Keze, Honorable Paulsen are each guilty as charged. But Honorable Mente is not guilty as charged. Charges against Honorable Mente be withdrawn against her. So, honorable members, we shall proceed in that order. I will now proceed to hear arguments in aggravation from the initiator. And proposal regarding appropriation sanctions. She has set 30 minutes to do so. Also regarding what are the findings from honorable committee members. Over to you, initiator.
Chair, may I please ask just for a a 10-minute adjournment.
No problem. Granted.
Thank
10
you.
minutes adjournment. Thank you.
Thank you.
Recording stopped.
Ngiyalo. Hello.
Ma'am, the mute,
You will advise, I believe the 10 minutes is done. Initiator, are you ready?
Chair, not yet. We're just waiting for the legal representative of the affected members. Just give us
Okay.
2 minutes. We'll alert you.
All right, thank you.
Chair, we can resume now. Everyone is here.
Thank you.
Recording in
Initiator,
progress.
we are now giving you space
Thank you, Chair.
to proceed. Yes.
Thank you, Chair. I take note of the committee's decision. Thank you. In respect of members Mr. Keza and Mr. Paulson, I respectfully make the following submission in recommendation of an appropriate sanction, and I refer to Section 12 of the Powers and Privileges Act. The first part of the sanction, or the recommended sanction is that both Mr. Keza and Mr. Paulson must give an unconditional verbal apology to the Speaker, the President, Mr. Ramaphosa, and to the people of South Africa for their conduct and for disrupting the National Assembly proceedings on 30 August 2022. And that the verbal apology, as I have now recommended, and in the words that I have recommended, must be delivered in the National Assembly no later than the end of February 2024. That is in terms of Section 12, brackets 5, brackets C of the Act. Then, Chair and Committee, my further recommendation is in terms of Section 12, 9, read together with section 12(5)(g), if I'm not mistaken, yes, thank you, that both Mr. Treza and Mr. Paulson be suspended from Parliament for 30 days without remuneration, and that the suspension is effected for the month of March. In other words, 1 March until the end of that month. Chair, the motivation behind the sanction is also that, and these are my instructions, that both Mr. Treza and Mr. Paulson have previously been found guilty in an internal hearing, also for disrupting the National Assembly proceedings on 11 July 2019, when the Minister of Public Enterprises, Minister Pravin Gordhan, during a mini plenary session of the National Assembly, and when he presented his departmental budget, they then also disrupted the proceedings. They were subsequently called into a disciplinary hearing, which they did not attend. They refused to attend, and they were found guilty by the committee. They were also, as a sanction, suspended for 1 month without remuneration. And just for good order, although the incident happened in 2019, they were found guilty in 2021. The National Assembly adopted the committee's report on 7 December 2021. Thank you, Chair and Committee. That is my recommendation for sanction in relation to both members. Thank you, Chair.
Thank you, Initiator. We'll now proceed to hear arguments in mitigation from the legal representative of the affected members. I now request the legal representative of the affected members to put to the committee arguments in mitigation and proposal regarding appropriate sanctions. You have got 30 minutes to do so, Advocate Gisibot. Thank you.
Madam Chair, my apologies. Before I hand over to my learned friend, I have omitted just to make a further point, which I do think is important. And if my learned friend and the committee would permit me just to place that one issue on the record.
Yeah, do that.
Thank you very much. Chairperson and committee, a further factor that underlies the proposed and recommended sanction is this, that other than the fact that Mr. Treza and Mr. Paulson are repeat offenders, during these proceedings, they showed absolutely no remorse. In particular, Mr. Paulson showed absolutely no remorse. He continued to be defiant. He was unapologetic and also disrespectful to the proceedings and to the committee. And that is an aggravating factor as to why the maximum sanction ought to be imposed upon him and them as the appropriate sanction. Thank you, Chair.
Thank you, Initiator. I will now invite Advocate Kasibote, the representative of the affected members. Over to you, sir.
Thank you very much, Chairperson. We equally note the ruling of this committee in respect of the 3 clients that I represent. Chairperson, if I may, Section 9 of the schedule to the rules of this assembly provides that the sanctioning, or rather the mitigation and aggravating circumstances, may be presented orally or in writing. Can I then please ask this of you, Speaker, that you allow me time to consult with clients on this? I should act on instruction at all times. My clients are not here, albeit virtually present. I'll still need to consult. And I do not ask this of you whimsically. I'm informed firstly by the finding against Mr. Paulson, for example, which finds him guilty of not obeying the instructions of the Speaker. We have led evidence which has not been contested that the Speaker never requested anything of Mr. Paulson. By extension, then he can't have disregarded the instructions of the Speaker. There's no evidence he did such. It could well be then that he might want to review that decision, and that cannot happen, obviously, if he is mitigating and being sentenced. So I'd want to canvass those aspects with my clients who've been found guilty. And if you'll permit me, Chair, and if this committee would permit me, you can put me on time frames as to by when I should have done it. But I would kindly request of this committee to allow me that opportunity to consult with my clients and for them to advise me on the mitigating factors. So for example, it has been raised before you that they've been previously found guilty. And to be quite frank, I was not aware of this. And I would obviously want to get their views on it, which will obviously inform the question of mitigation and aggravation. So with that, Chairperson, can I please seek that indulgence? And you have given me 30 minutes, and I suppose let me just by the way comment on a lighter note to give comfort to Tatum Lenzan, over and above confirming I'm not an EFF member, I've never been. I've in fact acted for the ANC on multiple occasions, including the Ezulwini matter, which is now quite topical. I regret to inform you that I lost that at the High Court, and I was fired duly. So just by way of record, I've actually acted for the ANC, and I'm happy to act for the ANC again, including this Parliament. Thank you, Chairperson.
Thank you, Advocate. Can I be given an opportunity to consult with members? Let's adjourn for 10 minutes. I'm chairing. I can't make a decision. I can't take a decision on my own. I must consult members, and then we'll come back. We'll give you an indication whether we agree with your request or we're rejecting it. Thank you. 10 minutes break. Honorable members only.
Recording stopped.
Chairperson,
Officials, can you allow committee members only to be on the platform? Is it possible to do so?
Recording in progress.
Chair, the only people who will be allowed to speak will be the members, Chair. No, not the affected members, the legal teams. Yeah, thank you, Chair.
Okay. Honorable members, here's the request before us that we grant the leader of the affected team to go and consult, and then we'll resume, we'll come up with a time frame. Just want to hear your views, whether we agree with this proposal or not. And it must not take time. Yes.
Sorry for interrupting
Who's speaking?
you. Sorry for interrupting you, Chairperson. We're just waiting for the legal team of the affected members. We are not in the chamber. We're just gonna call them quickly.
Okay. Hey, baby.
Switch off your mic.
Victor, you will tell me when it's right, everything is right.
Chair, we're still waiting for the legal team of the other side.
Okay, you'll inform me though, no problem, thank you.
Okay, Chair, we can resume now. The legal team is here. Thank you.
Okay, thank you. Welcome everyone. Honorable members, here's the proposal before us that we allow the leader of the affected team to postpone the matter for today and come up with a time frame. I just want to get a sense from honorable members whether you agree or disagree. Two things. Honorable members.
Mr. Ndlozi's hand is up. Deputy Chief Whip. Also.
Honorable Ndlozi.
And Mr. Dr. Klape, sorry for that.
Okay, Honorable Deputy Chief Whip, and then Dr. Klape, in that order. Who else? They're the only three hands for now. Honorable Ndlozi, you can speak.
Thank you, Chairperson. We agree with the proposal.
Honorable Deputy Chief Whip.
Thank you very much, Honorable Chairperson. Let me start by saying that yes, the proposal has been put on the table, but Honorable Chair, the mitigation should take place today in this meeting, because we cannot base that on the other charges, on the other case of 2021. So we are dealing with this one. So let's finish everything, Honorable Chair. If there is any consultation to be made, we will then, the advocate can do that with his client outside the meeting. But we must proceed. Thank you.
Thank you, Honorable Deputy Chief Whip. Dr. Klape.
Thank you, Chair. Chair, I agree that we grant the advocate time to consult with his members, but it has to be today. We agree on a period to give him that chance to consult, because, Chair, it is a fact that this process is something that we would know and preempt that today we'll do aggravating circumstances, matters, and finish. So my agreement is based on the fact that let's allow him time that we can agree on. If she needs 30 minutes, she needs 40 minutes, then let it be, so that we resume and continue with business and finish today. Thank you, Chair.
Thank you, honorable members. I in support with that, but let me also advise this committee as the chairperson. Honorable members, we had this program developed for us, all of us, and the two teams, the affected members and their legal team, as well as the initiator and the legal team of Parliament and our good selves. And we agreed, we adopted this program that we are moving forward. So, honorable members, I won't give the advocate time to consult, but I will give him, according to your request, time to prove what has been said. Is it true? There have been any other charges previously? Because it has got no relevance with today's meeting, because today we are dealing with this case before us. Those were just references, but to be transparent and flexible, we will grant him that opportunity just to check, verify with them whether this is true or false. I think it is in order. You are in order, honorable members. So by so saying,
there are two hands. You forgot to There
To
are two
check,
hands.
okay. Whose hands are up? Honorable members, gadgets are troubling them.
Majosi,
Or Honorable Majosi
And Mlenza.
and Honorable Mlenza. In that order, but sebesicela vele ngicela nikhulume because I don't want angifuni kunivalela. Honorable Mlenza, Honorable Majosi, over to you.
Thank you, Honorable Chairperson. Greetings to all honorable members present today. No, mine would be a quick, Chairperson. If that, I think on this case particular, we have given enough opportunity for both parties to go and consult with their clients and get a briefing of then how do they proceed. But in terms of maybe the sanctions that have been proposed, they have not even finished their 30 minutes yet. What I would do, maybe I would agree with Honorable Klape that maybe let's give them that 30 minutes of their own, because you provided them an opportunity for 30 minutes and they didn't use that 30 minutes to go and consult with their affected members and then come back, because I am running away from this thing of us having to take another 3-4 hours, Chairperson. We've got other obligations that we must attend to, and we knew that we must have this meeting, and once it ends, then we attend to other obligations. I wouldn't allow the fact that we take more than an hour. Maybe 30 minutes is good, and then they come back, present on their 30 minutes, and then we are done as the committee. That is what I would second to, Chairperson. Thank you.
Thank you, Honorable Majors. Honorable Mlenza.
Chairperson, in a second or two, I am covered because I would raise also the 30-minute maximum period for consultation. Thanks.
Thank you, Advocate. We're giving you 30 minutes.
Honorable Chair, before he leaves, my sincere apologies. Honorable Chairperson, the previous case is very much relevant to this one. I want to correct that, Honorable Chair. It's very much relevant when we want to impose, when we impose charges, because even in court, the advocate will know that they look if you have been convicted previously or not. So I wanted to correct that, Honorable Chair, and also to say that the honorable members were supposed to be in the hearing today, like they did previously. They attended the meetings, the meetings that we had this week. They were a part of the meetings, but today they are not here. Hence, we are giving the advocate 30 minutes to consult with them. Thanks.
Thank you, but to update you, Honorable Deputy Chief Whip, Honorable Paulsen was cut because he immediately started disrupting the proceeding in the morning. He was here, but let me allow Advocate to do what he wants to do.
I am here. What does the Deputy Whip mean now? Should be weak again.
I withdraw that. Thank you.
Why are you doing that yourself? Unless you are partisan.
Honorable Kaisa.
Why is she doing that?
No, stop that, please. Stop that. Advocate, I'm giving you that. We are giving you that latitude to can consult with your members. 30 minutes. Thank you.
Sorry, Chair. Before you go, can I address you quickly, Chair?
Yes, Advocate.
Chair, I might not need the 30 minutes in light of what I want to say, so can I please address you now and then you make a determination as to whether you insist I consult or not?
Yes, you may.
Thank you, Chairperson.
Unless you are defying the decision of the committee, because that has been my request that I consult, and we are now giving the decision of the committee. Unless you are saying you want to tell me that you are defying this decision.
I certainly am not, Chair. You might actually be happier with what I have to say now rather than taking the 30-minute adjournment.
Yeah, you may proceed, Advocate, no problem.
Thank you, Chairperson. The reason I'd asked for an adjournment to a later date was not purely to consult. That was a secondary issue. The primary issue was the exercise of my client's rights to present their mitigation in writing. So it was not just to consult, it was also to consult with client, put in writing which they're entitled to their mitigating circumstances. If the chair then says we will not allowed to exercise that right, then I accept the ruling, which then places me in a position where I have to argue in mitigation, notwithstanding the fact that we preferred to put it in writing. So if the ruling is that right is not granted to my clients, then so be it. And then in so far as the mitigation of sentence is concerned, we fully agree that they can't be punished twice. It's a whole double jeopardy rule, as they call it in the United States jurisprudence. The fact of the matter is they were punished for what they did, and that should be the end of it. It can't be that on a new charge, what you did previously and you're punished for again plays a role. The second reason we want to mitigate is it's an extensive shopping list for these alleged offenses. I say it is extensive because we persist that Mr. Paulson did not disobey the Speaker. That's just fact. Nowhere in these deliberations has it been shown that it happened. To then have such a punitive sentence for conduct that hasn't been proven is inconsistent with the rule of law. It is extensive and punishment enough to suspend someone from Parliament activities. That is a punishment in itself. My clients do not take joy in not representing their constituencies in Parliament. His rights and duties, the rights and duties of his constituents, are necessarily impeded by a sanction of 30 days. Then compound that with a deduction of salary for a full month is draconian, I respectfully submit. Over and above that, they have to suffer the shame of standing in Parliament and apologize to the nation. That in itself is extensive. And we say all of them taken individually are excessive. That is compounded if all three of those sanctions are required and are given. This is particularly so because we insist that Mr. Paulson did not breach the rules. We accept the finding that he did, but we persist that he did not defy the Speaker. As far as Mr. Gceza is concerned, no one has suggested that he's lying when he says, I was merely engaging the security personnel to say wait. No one has suggested that he did not say that. That could have been said to this committee had the persons he was talking to been called to this committee. A decision was made not to. That must count in his favor, at least in mitigation. We therefore say, Speaker, the appropriate sanction given the surrounding circumstances, one, the charge of Mr. Paulson not being proven but found guilty anyway. The fact that Mr. Gceza gave a version as to why he didn't leave, i.e., he himself was not proven to have deliberately disregarded the rule of the Speaker or the finding of the Speaker or the ruling of the Speaker. He did not. But accepting that you find that he did disrespect it, it's mitigating that it is not clear to this committee as to whether he intended to do that deliberately or not. In the circumstances, we make this submission in closing. A role of a member of Parliament is not for their own good. A lot has happened to bring about the constitution we have, to have all walks of life in this country represented by the chosen persons in this Parliament. Therefore, the role and functions they perform, including yourself, Chairperson, and the members of this committee, is greater than the individual being Mr. Paulson and Mr. Gbez. In essence, the punishment of any of them to not be in parliament to represent their parties is a punishment to their constituents as well. And we respectfully submit that in the circumstances, it will be draconian. In the circumstances, Chairperson, we make this request. And we make it simply because they are found guilty. We do not believe that they should be subjected to it. What may well be appropriate then, in the circumstances, Chairperson, is that a sanction of an apology is sanctioned against each of them, and the sanction that speaks to their performance of their functions in Parliament, and extensive sanction of their salaries is draconian and in the circumstances cannot be acceptable. Thank you, Chair and the committee.
Thank you, Advocate. Honorable members, you have heard both arguments in mitigation and aggravation and proposed penalties. It is time for us to deliberate on the appropriate penalties, considering the aggravation factors as well as mitigation factors put to the committee. The committee will have an hour to do so, but before that, before proceeding to deliberations, I will suspend the proceeding for 45 minutes. I will include also lunch to allow members to consult in private among themselves, and then we'll resume. Thank you.
Recording stopped. Recording in progress. Recording stopped. Recording in progress.
Chair, we are ready this side.
Thank you. Honorable members and our legal teams who are proceeding, I would now recognize members who would like to speak. So, honorable members, penalties.
Dr. Lotrit
I'm now
is
inviting
handing
hands.
up. Dr. Lotrit, so far.
Okay, Dr. Lutrick.
Thank you, Chairperson. We have now listened to the arguments in mitigation and arguments for aggravation. One of the points made by the advocates for the affected members is that they represent their communities and that they would be denied that opportunity. Chairperson, I think we have to understand as well that if you have that responsibility of representing a community, you actually have a greater care and duty on you to represent their rights by your behavior.
So I don't really think
Chair,
that could be
sorry.
mitigated.
Chair, my apologies. So, sorry, Professor, but we can't really hear anything. The sound is very bad.
Okay, I'm going to
Thank you.
try
I
to
wanted also to indicate that, yeah, we are
Okay,
just
Chair.
hearing bits and pieces, the doctor.
Chair, I am moving. I have a problem perhaps with connectivity. Is it better now?
No,
Little
it's
bit
not
better,
better.
doctor.
Okay, I'm just going to move outside. Maybe it's going to, I'll have a better signal there. Is it better, Chairperson?
Yes, you may try to speak while listening.
Okay. Chairperson, what I've said is that we have heard arguments in mitigation and for aggravation. I think it is important for us as members of parliament to also understand that when one says that you have the responsibility and the duty to present and represent communities, it also places a greater duty on you to behave in such a manner that you do not forfeit that right, because our representation and the rights and powers and privileges and immunities we have are not unfettered. There is a duty upon us to behave in terms of rules and the law. So I am not convinced by the mitigating arguments. I would, however, say, Chairperson, and maybe before I go there, the argument also in terms of double jeopardy, I'm not quite sure whether that is relevant, as these members were found guilty on separate incidents. So the fact that it was similar does not make it double jeopardy. That is how I understand it. So, Chairperson, I would say that the sanctions proposed by the initiator, I think, is suitable, and I would concur with those sanctions. Thank you.
Thank you, Dr. Rodrick. We heard you. I believe also other honorable members, the initiator and the advocate, have heard you. Any other hands?
We have Ms. Tseke and the Deputy Chief Whip of the Majority Party, Chair.
Okay, Honorable Tseke.
Thank you very much, Chairperson, and greetings to all the members connected and all the legal representatives present here. Chair, not repeating on what Honorable Lordship has said, I think all of us as members, honorable members of Parliament, we have a responsibility of keeping the decorum of the House when the House is in session, and representing the people that have elected us in a manner that is dignified. So I think after listening to all the delegates, Chair, I would want to also to support the penalties as presented by the initiator, Chair. One, in order to apologize to the President, to the Speaker, and to the people of South Africa in terms of Section 12.5c, physically in person in the House. And then secondly, as it was presented by the initiator, that members, the two members, Mr. Honorable Tessa and then Honorable Paulsen, be suspended without remuneration for a month starting from the 1st of March to the 31st of March in terms of Section 12.5G of the Powers and Privileges Act, read with Section 12.9. Chairperson, therefore I move for those proposals. Thanks.
Thank you, Honorable Deputy Chief Whip, Honorable Doris.
Thank you very much, Honorable Chairperson. I second and third the proposal made by the honorable members emanating from the ones from the initiator. We fully agree and support the presentation by the initiator. Thank you very much, Honorable Chair.
Thank you, Deputy Chief. Do you still have any other hands?
Yes, Chair. Majosi.
Honorable Majosi,
Yes, we are in agreement with the sanctions that have been proposed by the council, and we support it. Thank you.
Thank you, Honorable Majos. Any other hands?
There's Dr. Ndlozi.
Dr. Ndlozi, over to you, sir.
Chairperson, my apologies, man. I got a little bit cut off, struggling with the network. Just for your guidance, this is the time for our deliberations. Am I correct? I don't want to fire.
Yeah, you are correct. You deliberate on the two issues by the initiator and the defender of the affected members on aggravation.
No, Chairperson. I think that these honorable members should have been subjected to the same withdrawal of charges that was considered in relation to the national chairperson of the EFF, Commissar Veronica Mente. In particular, in the case of Nazir Paulsen, the initiator really couldn't prove her case. And I think that in the case of Mr. Keza, also, there was no grounds to could constitute a charge that he deliberately violated the rules. It's actually very much in relation to the explanation that he gave. It makes sense, perfect sense, in fact, that he had reasonable grounds to believe that his party leader could have persuaded the speaker otherwise. He had reasonable grounds to believe that the leadership, which is recognized by Parliament for that matter, and I saw the initiator trying to mock that particular structural organization of Parliament. We've got whips, we've got party leaders that are even considered different with remunerations. All of us work through these party leaders, through these whips. He had reasonable grounds to believe that some different outcome could come out of that exchange that Mr. Malema had with the speaker, which the speaker obviously completely decided not to respond to. I think that we have a simple situation here where the fact that they've already been kicked out of Parliament, lost time to represent and execute their constitutional duties, represent their constituencies, was punishment enough. It's not necessary to proceed again, try them in the manner that we have done, and then also impose those sanctions. I find them ridiculous. I find them punitive, not corrective. And if anything, above all, I find them political. And I want to deliberate as a final point about the political nature of this thing. The politics is that it seems to have been from how the House was run and how the House is constantly run in the majority of the cases. There's a serious discrimination on EFF members from those presiding officers, including the speaker on the day in question. None of that was considered. That there are many members of Parliament who kept standing, who kept making points of orders, who kept making inputs that were kicked out. There is a targeting of the EFF, and all of us are going to regret it. It's a matter of 6 months now. All of you are going to regret this discrimination that you show to shield the president from accountability, from radical accountability. But generally, even if you did not want to, the discriminatory practice, which was demonstrated by the advocate leading, representing Honorable Paulsen Keza and the Honorable Veronica Mente, that discrimination was not considered. And I would say that we must consider it and withdraw all these charges. They are not necessary. Thank you very much.
Thank you, Dr. Ndlozi. That's your view. Thank you for your input. Do we still have any other hands, honorable members?
Yes, Chair.
Dr. Tapu.
No, thank you, Chair. I was changing my gadgets for a better one that has got a battery life that will last. Chair, I have listened to the deliberations on aggravating circumstances, mitigating factors, and having participated also on these matters before us. I think one, we must consider the level of this, for lack of better word, misconduct where it happened. This is a national parliament where the country looks up to for an exemplary leadership. Now, if we put the integrity of parliament at a level that these distractions usually does, Chair, it gives me a problem. The members that have been found guilty here are members that represent constituencies at the highest level of government, probably leaders in their own right in the organization they represent. And Chair, when we started, I remember one of the members asked a question, do members of parliament get subjected to understanding the rules of parliament? And the response was in the positive. Now, it cannot be something that could say it had been an ignorance or unless for me, it's just a deliberate kind of an action. And for every misconduct, Chair, or behavior like this, there has to be consequences. And it is up to us as this committee, having listened to the sanction presented by the initiator, to say, how do we deal with this? Having said that, Chair, I think the sanction is befitting, especially looking at the level where this misconduct has happened. And so that it also works as a deterrent for future occurrences. We cannot allow, Chair, that each time Parliament of South Africa be subjected to such incidences. It's uncalled for. Hence, I support, Chair, the sanction as has been presented and agreed to the honorable members that are agreeing to the sanctions by the initiator. Thank you, Chair.
Thank you, honorable members. At this stage, honorable members, after your deliberation and your pronouncement on the appropriate penalties, I would like now to pronounce the decision of the committee that the penalty with respect to Mr. Kaiser is that in order to apologize to the President, the Speaker, and the people of South Africa in terms of Section 12.5C, physically in person in the House. And number two, the second penalty, the suspension of the members without remuneration for a month, starting from the 1st of March to the 31st of March 2024, in terms of Section 12.5G, read with Section 12.9. The penalty with respect to Mr. or Honorable Paulson is that in order to apologize to the President, the Speaker, and the people of South Africa in terms of Section 12.5C, physically in person in the House. And the second penalty is the suspension of the member without remuneration for a month, starting from the 1st of March to the 31st March 2024, in terms of 12.5G, read with Section 12.9. Honorable members, I request the support team to submit by a draft report to the committee for its approval, which if approved, will be tabled in the House for consideration. I would like to thank members for the work and time they had put on this matter. Our initiator, yes.
Sorry for interrupting you before you adjourn. I think there's something you forgot that the initiator had indicated in the proposal for sanction, which is that the apology should be before the end of February 2024.
Oh, thank you. Let me correct that. That the sanction, the apology should be done before the end of February. I'm adding that into those penalties for both honorable members, Mr. Krase and Mr. Olsen. Thank you for reminding me, Victor. Then I would like to thank members for the work and time they had put on this matter. Our initiator and legal representative of the affected members, their sterling work, and the support staff. Thank you so much. The hearing is adjourned.
Thank you, Chair.
Thank you, Chair.